We love hip hop.
Starting with K2, okay? K2, aka MrGoGetIt. He is the gentleman who got arrested a couple of days ago now from when we're filming this. He was arrested in Calgary. I need to give you a little bit of context, Jordana, just so that you can see who I'm talking about. He goes by the name of Isaiah Badger. Let me see if I can find him here. He got good SEO on YouTube here. If you could pull this up on the screen over here, one take, Jake. So this gentleman right here, and I'll play this is from a couple of weeks ago.
Absolutely brazen
Courtesy of
day-night
Crime Beat TV.
shootings.
Police announcing the names of the suspects they're seeking in 2 unexplained murders in the GTA earlier this year. On February 7th in mid-afternoon, 37-year-old Chandan Nanda Kumar was in his vehicle in the Woodbine Shopping Center parking
love
lot.
hip-hop.
While seated in his vehicle, he was shot multiple times and tragically succumbed to his injuries.
Police say the Brampton man was a family man with ties to the community.
Mr. Raja Nandakumar was not engaged in any criminal activity at the time of his death.
They're seeking 19-year-old Isaiah Thomas Badger of Edmonton, seen here on a Canada-wide warrant for first-degree murder. This is a still image from security video. Soon after the shooting, they say Badger went to Brampton.
Left in the crime vehicle, drove it to Clairville Conservation Area, where he lit it on fire.
Badger's also
love
wanted for
hip-hop.
first-degree murder in a shooting death on January 26th in Vaughan. In that killing, 65-year-old Sergio Lopez was gunned down in the parking lot outside his carpentry business. In that shooting, police say Badger had an accomplice, 19-year-old Jacob Wallace of
We love
Mississauga,
hip-hop.
who's also wanted for first-degree murder for driving the getaway car. It was disposed.
Okay, so we can stop it there. Now, they caught the Jacob Wallace kid maybe about a week ago, and now they just recently caught the Isaiah Badger kid. Now, the thing is with him, we've been following him because he was dropping music. But now people have been arguing with me saying, oh, that's AI. Even, the beat that he took it from is just like an industry beat. All that is besides the point, right? I'm assuming that he was dropping music while he was on the run. How cooked is he if he was one of your clients?
I mean, it depends what he's saying in the music. It depends what other evidence they have against him. You know, the police always put their best foot forward at these public service announcements. They don't, go through all of the evidence by any means. So it really just depends why they have connected him to each of these killings and what evidence they have against him. As we saw from that still footage, it looks like they got some pretty good surveillance footage. But again, I don't know. The fact that they've charged him with first-degree murder tells me it was a planned hit. Right? There's only so many circumstances in which someone in a shooting like that would be charged with first-degree murder, and it's most likely it was considered planned and deliberate.
Before you ask the question, though, there's more. Because there's so much lore that was going on around him the longer that he was on the run, that information started to accumulate on Reddit, on Torontology and Torontologists specifically, of messages back and forth or alleged messages back and forth between him and somebody else saying, I had to do it for my family, and all these different things, all these information basically. How does that help with somebody like this in a case like this? Because how do we even decipher what's real or fake? People are telling us, the songs are fake. Like, how, you get that on your table, boom.
So, I mean, that's up for the Crown to prove, but all of this information gets gathered by the police, and the police then will go and investigate whether or not any of it's true.
Which
and they'll
information?
compare
The Reddit stuff?
They compare what's online to mostly what's in people's cell phones, right? And one of the biggest sources of evidence against people these days is from themselves. It's them, sending photos, sending pictures, sending voice notes. If it's a planned hit, and let's say, for example, it was something that he was contracted to do, there might be evidence of that in his phone.
A paper trail.
And so the police will compare that. Now, will the Reddit messages that don't involve him be submitted in court? Will that ever go to the jury? No, it won't. It's not usable evidence from a court perspective, but it will all be used to further the police investigation, because the police need to figure out what happened here.
Yeah, you had a question?
Yeah, so Jordana, if K2 is your client and he's facing 2 charges of first-degree murder he's 19 years old from an indigenous community and he went cross country fleeing the police. Like, what is your goal in terms of sentencing for him? Because they're going to try to charge him with like 2 life sentences, I guess, for first degree.
Well, first degree murder, you don't have any options. It's an automatic life sentence with no parole eligibility for 25 years.
So
there's
like,
nothing to argue.
How would you
You're
approach
done.
it, and what would you try to get it down to? Like a manslaughter or something? Like,
Again, that's situational. Manslaughter is very, very difficult. Maybe a second, maybe there really is no evidence of planning and deliberation. Maybe if it's a second degree, he's still looking at a life sentence. Like whether it's first or second, it's an automatic life sentence. It's a question of when you're eligible for parole. So for second degree murder, your parole eligibility is a minimum of 10 years and a maximum of 25.
Yes.
So, I mean, again, it really depends on what actual evidence they have against him. And that's something that we would have to review in the disclosure. But at the end of the day, if this individual's killed 2 people in cold blood, no reason in the sense of like not acting in self-defense. It wasn't an accident. He wasn't playing with a gun that, just accidentally went off.
Yeah.
There's obviously defenses in certain circumstances, but if there isn't, when we talk about parole eligibility, he's still got to face the parole board. He still has to convince the parole board that he's not going to be a menace if he gets out, and he's not going to hurt anyone else. And that's going to, obviously be an uphill battle.
And there's also the families of the people, the victims, basically, that are going to be like, no, we don't want him back on the road.
Of course.
Yeah.
So it depends. That said, he's only 19 years old. Are we going to write off a 19-year-old? Like, in my mind, there's a big question of why. What's going on with this kid?
Yeah.
If he is factually guilty, if he did what he's accused of doing, like someone at some point has to parse out the why. Why do we have a 15-year-old killing random strangers? Like,
well, what I'm thinking is they're saying it's first degree.
Yes.
You know what I mean? So they're saying it's planned.
Yes.
If you look at the victim and the suspects, it didn't really seem like 2 people that would like know each other. So I feel like maybe there's like either evidence that there was a plan, or like maybe someone's cooperating that would say that it was a hit. And if it was a hit, then like that's the motive right there, money. Like a lot of these kids do need money. They want it the fast way. A lot of them are applying for jobs and not getting jobs. And when they do get the job, it's like, it's not covering anything. You know what I mean? So
yeah, and people will give them 30 racks for a hit.
And in the case of 2 individuals like this, if they were to offer information to law enforcement, could that lessen their charge? Like, are they going to be offered that where it's like, who sent you on this hit, or they wouldn't care?
They're not going to care.
Really?
Yeah.
Damn.
They're not going to care.
And-
You're not going to see a first degree murder go to like a manslaughter for some information.
For snitching.
Like,
Yeah.
The reality is whatever information they have, the police can likely get from another snitch. They're not going to have like such inside scoop about who's at the top of the hierarchy that, that hired him. Because the person that hired a kid like that is so far down the rung anyways. He's like 1 or 2 levels above at most.
Yeah.
So he's not going to have any information on who's at the top.
Yeah, that makes a lot of sense. Also the music aspect, because we were covering this and we were like kind of impressed with some of the music, but I felt like a lot of that stuff might come up in court. What's your thoughts on that?
Yeah, you should show her some of the music. One of the lines in the song was like, caught one in the Rex, caught one in the West, like as if like he caught 2 bodies.
Yeah, it's not good.
It's not going to help his
It's not
case.
good.
No.
If I'm the lawyer on that, I'm not happy.
That was like the first bar.
Oh my God.
that's like
Yeah.
admissible evidence.
Yeah. If they can prove that it's him and he, put this song out after the murders happened, because that's one of the problems, right? They have to establish that there's like relevance. So if that's a song that he, did 5 years ago and it was before these guys were killed, I would argue like it's not relevant because it can't possibly relate to a murder that hadn't happened yet. But if it's like 3 weeks later and he's living comfortably out, in Alberta
boonies.
somewhere, and this is what he's doing with his time, like it's first of all, him running is a problem. It's consciousness of guilt.
Yeah.
It shows that he's got something to run from.
Say that again.
When you run away, it's called consciousness of guilt.
Consciousness of guilt.
Yes.
Interesting.
So it means that you are conscious of the fact that you're guilty and that you've done something wrong, which is why you're fleeing the scene. And so there's that for the lawyer to contend with, and then to also, have these songs where he's mentioning 2 bodies. It's a problem.
Okay,
OJ,
so
right?
I'm gonna play a little bit of it. Man. Oh, what a tangle web we weave. Okay, I think you get the point.
I love that he says, "I'm never talking."
You're talking right
Like
now.
in the song, he says, "I'm never talking." Like,
But when Gary Grill defended Top 5, like, did that kind of set precedent when it comes to using rap lyrics in the courtroom, because he kind of accredited it to persona building as opposed to admission of like reality?
Great question.
so he did, in terms of there's a possibility to challenge these things. He was challenging Instagram posts. And so he was successful in keeping all the Instagram posts out, and that was all the Crown had. There was nothing else other than these Instagram posts, which is why the
Yeah.
Crown stayed after the application was successful.
So there's a precedent set now from that case. Like,
That it can be
reference
argued.
it?
That it can be argued. Yes, again, everything is like fact specific, like everything in the law. So it doesn't mean that songs can never be used or Instagram posts can never be used.
Yeah.
But in that circumstance, for Top 5, the judge said this is not relevant to the case. It's not directly
Interesting.
relevant.
'Cause
It
aren't-
doesn't directly implicate him.
Aren't there
Interesting.
like precedences that would like state the opposite as well?
Yes.
So it just depends on like the circumstance in which your client is in.
Yes, I mean, look at Lamar Skeet. So he's sitting in jail for the rest of his life. He got convicted of first based on a song that he wrote while he was in the Don.
Don't
Oh,
crack to the
really?
coppers.
Yeah.
Oh wow.
That was the bar.
Oh,
We
wow.
don't crack to the coppers. And they said that line.
That one
mean-
line.
Yeah, because, and salute to Lamar Skeet, right? They said that he murdered a man by the name of Kenneth Mark, but because this guy was a community activist, and obviously he doesn't crack to the coppers. And this is the mentality that I'm just thinking that the Crown was using as far as their argument, right?
So it
He
wasn't.
used a bar saying we don't crack to the coppers, so he's talking about him. But
yeah,
that song was recorded like years prior when he was doing time in the Don jail,
yeah.
and that was the argument. But to this day, he's still locked up.
Yeah.
Wow.
And that case went all the way to the Supreme Court of Canada.
Yeah.
Wow.
And the Supreme Court of Canada did not overturn.
He's still
So-
dealing with something right now. He's about to do like a big meeting with the courts as well. So
He's doing
still
really
fighting.
good. He's teaching in universities right now. Like he's really trying to like help people. He's really using his time wisely.
Yeah,
And
yeah. And imagine, and that was back in like 2012, if I'm not mistaken.
I think so.
Right?
Yeah.
We don't crack to the coppers. Look what they're saying now. You know what I'm
Yeah.
saying?
No, for real.
They're just giving it to the freaking Crown at this point. This Crown Music was a good title from the beginning because like
Yeah.
they're literally giving the Crown what they want. What about the AI argument though? Because people are saying this is AI. Can that be argued in court?
Absolutely.
Tell me how.
Well, I mean, the Crown has to establish the authenticity of any video or surveillance,
Mhm.
right? That's the Crown's job. So, if I'm representing him and he says, "Listen, that's not my song. That's not me. Someone took my voice. Someone created this. This is bullshit." Then I make that argument. I'm not going to concede authenticity, and then it becomes the Crown. The Crown's going to have to hire an expert. The expert's
I'm
going to
about
have
to
to
say.
analyze the video, and they're going to have to figure out how to prove it's not AI.
Wow.
Mhm.
Okay.
New world problem.
I have a question for you. Let's say I committed like a heinous crime or whatever, and I come to you. Is it best that I be completely honest with you, or is there certain things I should leave out so you could have like that, like that
Reasonable
ignorance?
doubt?
Yeah, yeah.
So I start with not asking my clients to tell
Okay.
me what happened. I
Okay.
start with, what are you charged with? Who are you alleged to have harmed? Who are your co-accused? That's just for me to make sure I've never represented them. I want to make sure that I don't have any conflicts. I get a little bit of background about the case, and then I say, okay, let me get the disclosure, and I'll go through it, and then we're going to sit down together and we'll discuss. And that's what we do. We go through the case, and I lay it out, like a jigsaw puzzle. Like
Yeah.
this is what the Crown has. This is what the Crown's saying. Talk to me. We have this piece of evidence here. You have this song here.
Mm.
Is that really you or is that AI? Right?
Yeah.
The police are saying that you've got these photos in your phone. Are they actually in your phone? Are you
Yeah.
really taking photos of yourself holding a gun in the mirror of the bathroom?
And
of
he
the
has to tell you the
Airbnb? Like
truth.
why? Well, I mean, it's gonna only hurt him if he lies to me,
Yeah.
right? Clients lie to me, it doesn't
Yeah.
help them. And they know by that point, like by the time we get the disclosure, which could take 4, 5, 6 months, sometimes 7 months, depends. I'm not there to judge them.
Yeah.
Right? Like if I've taken on the case, whether they've done it or not doesn't matter to me.
Yeah.
So the answers to those questions should be truthful because it helps me help them. And by that point, like by the time we're going through the disclosure and talking strategy, like there's that level of trust. There's that level of, respect. He knows that I'm like going to do the best that I can for the circumstances he's put himself in. And lying to me, it doesn't work. Like I've had clients that, they get themselves convicted because they lie in the stand.
Yeah.
And the judge catches them in these lies that I told them that you shouldn't be telling. Like it's hard. It's difficult situations, but some people just can't be honest.
So if you know that your client is guilty, is the best strategy to find a loophole, like find a way out, or I guess find the most smallest sentence for them, like the most minimal sentence?
I mean, it depends on the circumstances, right? Like again, for me, it's not about whether or not they've done it. If I know that they've committed, a certain crime, I can't put them on the stand to say they didn't, right? I have a duty as a lawyer. It's called, I'm an officer of the court is what they're called. But, I can't suborn perjury. So, if you come to me and you say, yeah, I was in whatever, a bar fight, I know I hit the guy. When I look at the surveillance video, maybe I don't see that it's you, right? Maybe it's like archaic surveillance footage. Maybe you're wearing a mask. Maybe I just can't tell. And so I can argue in court that the Crown can't prove it's you, but I can't put you on the stand to say that wasn't me. I wasn't there, right? Because I know that's not true.
Yeah,
so
now it's perjury.
Now I'm suborning perjury. I'm like, I'm teaching you to lie on the stand. So we're not allowed to do that, but I can still argue that the Crown can't prove it's you. So there's nuances we can work with.
Yeah, super interesting.
When you represent a client and you're defending them and you're presenting your arguments, whose authority are you seeking to appeal to more, the jury or the Crown?
No, I don't care about the Crown. It's the judge or the jury. So if it's a jury trial, then I want to convince the jury.
Okay, yeah.
And if I'm just in front of a judge, then I need to convince the judge. I don't ever need to convince the Crown of anything. They got their job to do. And the reality is, by the time we get to trial, I'm not going to convince the Crown of anything. Right? The Crown believes in the police theory, and they're going to fight as hard for that as I'm going to fight for my client.
Yeah.
We're not going to, there's no negotiation at that point.
So when it comes to the judge versus the jury, you're always just appealing to the jury. Like the jury has more authority in Canada.
So
would you say?
No, when there's like a judge and jury trial, there's always both. When you have a jury, there's always a judge there. The judge decides the law. So if there's a legal issue that has to be decided, it always goes to the judge. Factual issues go to the jury, and then the ultimate verdict goes to the jury. So let's say, you've got this trial going on. Let's say there's like pretrial motions. I'm trying to get a piece of evidence excluded. That decision gets made by the judge and the judge alone. The jury's not there to watch it. Then the Crown presents their case to the jury, and the judge is obviously there. Let's say that you're trying to do something shady. I object to it. The jury gets excused. We argue in front of the judge. The judge decides where the law is at on this piece of evidence. And then the jury comes back. The jury hears the rest of the evidence. I call evidence or not. I don't have to. It depends on the case. And then the lawyers and the judge talk about what law they should present to the jury so that the jury knows the legal tests. And the jury alone decides what the facts are. So if there's competing facts in a case, it's not for the judge to decide if there's a jury. The jury decides what the facts are, and then the jury takes the legal test that the judge gives them and applies it to the facts.
So is the judge able to appeal the jury's decision?
No.
But are there moments where they're not in congruence, like the judge and the jury are kind of like opposing, or it's usually like it all comes together?
Don't know, right? We never know what the jury deliberates. So the jury goes back into a little room. They get their coffee, they get their meals, and they discuss amongst themselves. It's illegal in Canada for jurors to talk about what happens in the jury room, subject and except for questions that go to the judge that they have to write down, and the judge has to talk to the lawyers. Like it's a very, very rule-based system. Everything is stipulated in terms of like how we maneuver, and so judges have to tell the jury what the law is. The jury doesn't tell the judge what facts they found them to be. They can ask questions of the judge, and the judge will decide that with the lawyers together. And so juries don't give a reason as to why they decide how they decide. They just come back and they say not guilty or guilty or guilty of a lesser included offense. So let's say someone is facing first degree, but on the facts, they might be guilty of second or manslaughter. The jury gets all of those options. They come back. One person stands up and says, not guilty of first degree murder, but guilty of the lesser included offense of manslaughter. And then that's it.
No explanation.
No
needed.
explanation given.
That's crazy.
So if there's an appeal to be had, the appeal goes to the Court of Appeal, not the judge who sat in on the case.
Mhm.
And the challenge is usually to something the judge did, because we never know, like no lawyer knows why a jury decided the way they did.
Wow. Listen, for anybody also, and for K2 or and the next guy, I forget the white
Jacob
kid,
Wallace.
Jacob Wallace, because I feel like, again, I keep on saying this, I feel like they watched the show. You know,
Well,
you
not
might
anymore.
have learned some legal advice from this show right now for what you might have moving forward down the road, because you're gonna have a long journey.
19, bro.
Yeah. Couple of
Sad.
things.
It's really sad.
Yeah, it is.
We
Thanks
love
for
hip
watching.
hop.
If you enjoyed this video, please make sure to check out these other videos on the screen and make sure to like and subscribe.
We love hip hop.